Good morning. Today being the 10th of February 2026, this is an event involved before the Justice Commission and Honorable Justice Mazibuko. Calling matter number 3 on the event involved is the matter of the Legal Practice Council of South Africa versus Mohalua Grace Ukova plus 1, case number 01087, 9 of 2026.
Thank you. May I please call my ladies? I'm on behalf of the Practice Council in this matter, the applicant. I don't believe there will be an appearance. Thank you, my lady. My lady, your ladyship received from the practice note that this matter has become settled insofar as the respondent has agreed to her suspension. The confirmation letter from her attorneys of record can be found in section 13.1 sub-part 2. Beg you to fill up a copy of the draft.
So the draft order is per consent.
Per consent, my lady. I do have a copy, a hard copy of the letter of consent.
Having had counsel for the parties and by agreement, the draft order is written.
May I please call my ladies? Thank you.
Lady, I am actually here to note a matter. I'm a matter of an action on the urgent role for respondent, the Bukwa matter.
No, we were here only for this matter. We were not dealing with the other matters. The court will attend.
Yeah. She's coming back. The older one or the younger one? She was trying to do the first one. Yeah? Where are Which ones are we using? This one? we're going to present from there. So, but then
No, I think it's fine. just do this once. Yes, we can proceed.
Calling them for all to go to the board with the letter of material concerning legislation of provision case number 01171 of 2026.
As it is the court, my lady, I confirm my appearance on behalf of the applicant in this matter. My initials are DB, surname is Melanie.
DP,
DB.
DB. Velapi, yes. Okay.
As the court pleases, my lady, it's only an appearance of the respondent.
Who is it for the respondent? Who is it?
I beg your pardon, my lady?
Your name?
It's Owen Muiman.
Owen Mudiban.
Indeed so.
Thank you.
As the court.
It looks like your colleague is surprised that you are standing up in court. Were you not aware he's here?
No, I was not aware. We never received any papers.
Mm.
My lady, I think that statement, my lady, is incorrect because the document had been sent by email yesterday.
Which
the proof of service on the email, my lady, which we also send the said document via email to your register, as we didn't have access to case line. I have to request my lady's colleague to give me access to case line.
Okay. You know, I'm going to stand this matter down and just go out and talk, and then you can come back. Matter stand up.
Calling matter of 14 on the road, the letter of Thabo Bester, others. Case number 021077 of 2026.
As the court pleases, my lady, I am Advocate BMWM Maila, standing for Benjamin Africa Maila.
You are BMWM
BMWM Maila.
Maila.
Yes.
Stand, and then you are standing for who?
For the applicant, Mr. Thabo Bester.
Okay.
As the court pleases.
No opposition?
There is.
Please put the lady. Neil Stellenberg from the Rebuttal.
Can I get your name properly, Mr.
Neil Stellenberg.
Stenenberg? Thank you.
Here we are with my colleague, Mr. Hughes, under Mr. Rebuttal. We full respondents in this matter.
Thank you.
Lady, I'm not alone. I'm with my colleague here. My lady, firstly, I would like to bring it before to the attention of the court to say.
Before you proceed,
Yes.
this morning I received a letter from SABC. They would like to televise the proceedings. So I do not have any objection. I don't know if anyone has an objection it being televised.
My lady, I personally have no objection, and according to my instructing attorney, we know the public interest in this matter.
Correct, then it can be televised. Let's say
As the court pleases. My lady, I will firstly like to bring the court to the attention of saying procedurally this matter has been ambushed because the respondents did not serve much. They only did a notice to oppose, kept quiet for days, And only this morning around 9 o'clock, they only filed heads of arguments. No answering affidavit was filed, and the heads of arguments were only received this morning at 9 o'clock, should I say. And that's what we are having. I'm not sure if this has to be attended to by the court before we proceed, or that is how they want everything to proceed. As the court pleases, my lady.
Lady, you will see in section 11 on case lines, heads of argument were indeed filed, and it only relates to the matter of urgency. We respectfully submit that this matter is not urgent, shouldn't be heard on an urgent basis. Alternatively, a postponement should be granted, affording respondents a reasonable opportunity to answer the case that has been put forth. I've got a set of heads of argument and hard copies for my lady. Our learned colleague has a set. It deals only with the matter of urgency. You'll see the conclusion, my lady, is that the matter should be struck from a roll for a lack of urgency. Alternatively, we ask a postponement, a reasonable time for the respondents to answer to the allegations in the papers.
Have you discussed with your colleague about?
No, we have not had any discussions around that, my lady.
Do you need time? I think you should take time to discuss it, because if we go into the issue of agency, the postponement will fall off naturally. Because if I decide the matter is urgent, then the issue of postponement is another thing. But if at all you agree on a postponement, we'd rather go directly to the postponement.
If it pleases you, my lady.
Yes. Mr. Maile.
As the court pleases, my lady. It is the practice of this court that you rise and fall by your papers. And if you have no papers, you've already fallen. So now it is therefore our assertion that this matter is urgent and must be heard on urgent basis. We did submit volumes of papers, starting with our founding affidavit, coming with the heads of arguments, the practice notes, alluding to the fact that this matter is urgent and must be heard on urgent basis. Therefore, when my learned colleague or the respondent says we need to postpone this matter because it is not urgent, it therefore creates for us a simple situation of saying it means everything else that we are raising on our papers, it is not heard or read. And it needs to be entertained in court because we have raised legit issues that are legally grounded, constitutionally based. It is not anyhow intentional on our side to say we need to postpone this matter, because it is also the instruction of the applicant, our client, Mr. Thabo Bester, that this matter need to be expedited. Because, my lady, all the reasons we have stated down without entertaining the matter, just answer my learned colleague. We are in a trial. We are in the middle of a trial preparation in Bloemfontein. And then our client is moved 750 kilometers.
Let's not go into that. Let's just discuss this issue. You are not for postponement.
I'm not for postponement, and I'm saying let them argue the agency. We argue the agency. Should we pass the issue of agency that the matter is urgent, then they can keep quiet and listen to us reasoning our case going forward. Maybe, my lady, at that point, that's where you will try to assist them by asking us questions, because they cannot speak anything they never filed, as the court pleases.
Do you want to respond to that?
But if my learned colleague wants to argue the urgency, this matter is not urgent. I mean, they gave us a date to give notice to oppose and a date to file an affidavit.
We're not discussing it. I just wanted to hear if they would be amenable to a postponement.
They are not, so
they are not amenable.
yes.
So it means we're going into the issue of agency.
Yes, and they must obviously satisfy you.
At the moment, because I only just received the heads of argument, I would like to go into them, and then we can deal with the matter. So the matter will stand down for me to go and read the evidence.
If it pleases the court.
Let us stand down. The matter will stand down, but we can do the other one. Where is the there is another matter. Okay.
She has another matter.
Calling matter number 22 on the roll is the Mr. House Martin Kole, Yaba, the South Minister of Communications, Part 1, case number 016016 of 2026. Calling matter number 22, Kole, Yaba, the South Minister of Communications, case number 016018 of 2026. No appearances.
Did you check in the morning? Kero, we did not check for that. Yes. Stand down. Matter will stand down. Court agents.
All right.
What is the date, Friday?
It's the 13th.
That
The 13th.
1-3. Okay, yeah. The matter can stand down. Matter will stand down to the 13th of February 2026.
As a court, please. Thank you.
As the court, please.
We call it number 14 of the law is the matter of Thabo Bester, versus matter of Commissioner of Justice, others. Case number 02-1077.
As the court pleases. My lady, I do believe that the first thing which we need to engage is appointing limit on agency. And on our heads of arguments, agency appears on page 009-8. It's paragraph 23, 24, 25, 26, up to paragraph 27. And the same, my lady, we did address the issue of agency on our funding affidavit, extensively so. Now, my lady, the question of agency, as we know, primarily it relies on Rule 12, subsection 6, therefore which has been explained in the case of Luna Mabel, which has stated two important requirements for an agency. Number one is that the circumstances of the case justify the shortening of times and the non-conformity from the rule. Number two is that if the matter is not heard urgently, that the applicant will not be afforded substantial redress at a later stage. Now, my lady, we have stated in our funding affidavit that the reason we have approached the court on urgent basis.
For purposes of this matter, I seem to be thinking that the agency should be divided into two portions or sections, if I may say.
Yes.
The timelines that you have set for yourselves in this application are truncated. So the first step is to explain or give why the truncated time frames. And then even after having explained that, there is also an explanation to say even if it can be found that the truncated timelines are too stringent, but does the matter remain urgent? So if you can argue that first requirement in those two sections.
As the court pleases, my lady, I appreciate the guidance of the court. I will therefore abide. My lady, the timelines that we have brought forth on this matter, they are guided by a fact that we are in the middle of a trial with the applicant, Mr. Thabo Bester. And we were going through an extensive process of trying to prepare for a trial that will be set down on the 18th of March, 2026. We did state that on our papers.
No, that time doesn't come out. That date is not in the papers.
My lady, I will show it to you where it is in our papers.
Yes.
When this matter, my lady, when this matter arose on the 26th of January to say they are moving the applicant, Mr. Thabo Bester, to Ebongweni Supermax, it was at the time when we had a court case in Bloemfontein on the 5th of February 2026, which was set down to be heard on what we call the conditions application, dealing with Khosi Mampuru to say we are not able to consult with the applicant. Now, already as it was, my lady.
But for that case in Bloemfontein, were you supposed to have consulted? Because your paper says that he will be representing himself.
Yes, my lady, we have already prepared everything and he elected to represent himself. Now, I am explaining this. When we were on when the matter was going on the 5th of February, already on that note, we already had a complaint of saying in that application, we are unable to consult with the applicant in Khosi Mampuru. We request that we be allowed to consult with some of the gadgets since the evidence of this, of the main trial in Bloemfontein is electronic. And we did also state to say the conditions at CMEX of consulting over the phone through the window, they are not favorable. Now, as we are busy preparing for a trial which will be set down on the 18th of March, now it shows us to say we do not have more time to prepare for a trial. So the reason we say when the first respondent, the correctional service, move him to Ebongweni Supermax, it then cripples our case because we are completely failing to consult. So why then did we have such truncated times in our agency? I am answering the question. It's because, my lady, we are in the middle of trial preparation. Even though it is not effective consultation, because we can't come in with all these things that I mentioned, the gadgets, the laptops, and other instruments in order for us to properly consult. Yet we are in the middle of main trial preparation. When they move him like they did, it has now affected our preparation completely, because he has been moved 750 kilometers away from us. And when he's moved 50 kilometers away from us, it makes it necessarily impossible for us to be able to consult. Why so? We cannot drive daily from Pretoria because the instructing attorney and the counsel, myself, we are based in Pretoria, to Ebongweni, Kokstad. It will be quite cumbersome financially, energy-wise, and otherwise. So we are raising these issues to say we have a trial that we are in. And already in that trial, we have been reprimanded by the presiding officer, the judge in Bloemfontein, that Thabo Bester's team seem to be wasting time, not wanting the matter to sit down because of some of these applications that are lingering. Now, we are requesting that he be brought back on urgent basis so that when we go to court on the 18th of March, we are able to argue to set the matter down properly, since that is the last case management as we've been warned by the court. Now, my lady, coming to that, when we say this matter is urgent, we are also looking into all other factors that surround the whole issue. The accused person is taken from Khosi Mampuru. He is then dropped somewhere there in Ebongweni Supermax without, number one, engaging the legal representative, being the attorney or the advocate, whereas they have all the communications, because when we visit them, we leave our details, which they could have done so to allow us an opportunity to give them representations that tells them why we are not in favor of him being transferred. But the correctional services has never even taken any efforts of trying to say, these are the reasons why we are transferring him. That's why, my lady, even when we send our papers, they couldn't even reply. They couldn't send forth any reason why they had to do so. Whereas the attorney has sent an email requesting that tell us your reasons why are you transferring him, because we do need, he stated all these reasons, we do need an opportunity to consult. We have requested previously an opportunity to have effective consultation, but none of those has been had. But instead they increase our crisis by taking him to Ebongweni, which becomes a triple case on its own. Now consultation completely cannot happen. Why? Because when he is at Ebongweni, he cannot even phone for more than 5 minutes. Every time when he phone the instructing attorney, it will be for a minute or so. So there is no any form of preparation that has been done. Therefore, that infringes on his rights. That's the reason why, my lady, we are in this court on urgent basis. And my lady, the reason we are bringing this on this truncated time is because we have not any much time to prepare. We are already struggling with preparation for a trial. And now, when they take him far, they make us suffer all the more. So therefore, we cannot wait any further and say, let's give it a month, let's give it other weeks, because it will be next month where we are expected to be ready. And at all, we are not ready. And Department of Correctional Services knows that there is an application that says situation at Kosi Mampuru is not favorable. But yet they ignore that. And they still move him to Ebongweni, which does not become only unfavorable. It becomes impossible for us to do our work. So, my lady, this whole thing, if it has not been viewed, cannot be viewed as urgent, it becomes a problem to say, how then will we be able to consult? Because a right to consult with your legal representative, it is there in the Constitution, a protected right. A right which also influences a right to a fair trial, which also continue to speak about a right to adequate facilities and preparation. So all these rights brought together, they have to create an agency to say, here are the rights of a detained person who's supposed to stand a trial, and his rights are being violated. And also the respondent, being correctional services, has already acted unprocedural and unfair and unreasonable procedurally by firstly moving him without even notice or any form of communication. If they could have at least told us that we're going to move him in 2 weeks' time, we would have tried to create time to finish whatever we could finish in order for him to move without us having a burden of preparation on our shoulders. But instead, they invented the whole wheel of moving him overnight. The following day, we received 1 minute call to say, I am at Ebongweni. And then now, what do we do from there? We just have to approach the court and say, the court, here is the respondent who have acted arbitrarily, who have abused the power and the authority that they have. They have acted unfairly. So that's the reason why we have approached this court on urgent basis. And it cannot be ignored to say when the rights of a person are violated, agency right there, it has to be kicked in, it has to come in, because agency speaks about a necessity to find a remedy. If ever this matter is not heard today, the question is that when will we have an opportunity for this matter to be heard, and what will be the redress at a later stage, because we will be unable to go for a trial which needs to be prepared for. So my lady, it is on this case to say, it is on this facts and that I'm presenting before you, to say this matter remains to be urgent. It remains to be urgent. If we can say we don't hear this matter, let it be postponed to next month or any other date. The question that I'm having is that how are we going to be able to prepare for a trial? And how are we going to be able to consult with our client in order for us to prepare for the trial that is awaiting? Are we not suspending the will of justice for the matter of Mr. Thabo Bester to be heard? We are doing so. So the decision to move him to Ebongweni Supermax, it was untimely, it was unfair, and it was unnecessary for the first respondent to do so. It is therefore our request in our papers to say this matter be heard on urgent basis. The rules be relaxed. Because when we come with Rule 12, subsection 6, we are speaking about saying we can bring the times to favor what the dates that we are working on. It should not be following a normal procedure. Why should we be following a normal procedure when we say the matter is urgent? Because if we have to follow a normal procedure of 15 days, of what days, then the matter will be heard in almost a month. When that month comes, my lady, then we will not be having any readiness for a trial that we are facing in Bloemfontein. That's the reason why we had to come on truncated times that we are in. I hope I have answered the issue on truncated time, and my lady said we must divide it into two. If you may remind me, my lady, on the second part, so that I can also venture on that in more details.
Before you pass that one, Let me just go into your papers. In your founding affidavit, what page do we find the agency?
In our founding affidavit, the agency will be on page. It will be on page 001-11 until 01-12. That will be paragraph 4.1 to paragraph 4.7, my lady.
Yes. Remember, for me to be able to decide whether this matter is urgent or not, I depend on what is said in your papers, in the founding papers.
Yes, my lady.
I indicated to you that the date of the trial is not set out in the founding papers. So for me to be able to determine whether this matter is urgent without that date, it's going to be difficult, because that date should say to me, if you keep saying it's the 18th of March.
Yes, my lady.
If it's the 18th of March, it enables me to be able to say, indeed, this matter is urgent, because by the 18th of March, these people must have prepared or must have consulted with their clients. But when that date is not in the papers, how do I come to that decision? How do I know that this matter is going to be, the criminal matter is coming on, the Bloemfontein criminal matter is coming on next year or in 2 years' time? How will that become urgent? Because, if I may also add to that, because that issue of the application of the 5th of April, it has gone and passed. It can never be part of the agency now, because it has gone and passed. We are only remaining with this one of the criminal trial that you say is coming up on the 18th of March, but it is not in the papers.
My lady, the issue of ongoing trial of Thabo Bester is what we can take a judicial notice of.
Pardon?
The matter of Thabo Bester, the main trial of Thabo Bester that is ongoing on Bloemfontein, we can take judicial notice of it. It is also communicated in our papers to say the applicant is a detainee who is awaiting trial. We do explain that to say he's the 7th accused, all these issues.
That I understand, but the issue for me is the truncated time frames. You have given the respondent 1 day to oppose, 1 day to file answering affidavit. Those are very stringent time frames. So I need to understand from the papers that you have set out, why do you have such stringent time frames? And when I do not have a time period or a date on which this criminal trial is going to be held, how do I determine that it was indeed important that you bring this matter on such stringent time frames?
My lady, on the issue of agency, as you have already communicated, we stated out all the reasons that have to be considered by the court to say this is what informs our agency. And in saying that, my lady, we did explain the most important issue in it to say, if ever this matter is not heard on urgent basis, there will never be a redress at a later stage. That redress.
That is why, Mr. Maile, I said to you that agency needed to be divided into two arguments. The truncated time periods. Why did you have to bring this matter on such very short notice to court? Explain it. And then you can come then and say, indeed, even if we don't consider the truncated time periods, this matter remains still urgent. and we look at those circumstances that we want to stay. But before we get to those circumstances, we must pass that hurdle of why the truncated time periods, and how will I, looking at your papers as they are filed or as they are before me, what is that will make me determine that indeed you're required to have this truncated time periods?
On the truncated time, my lady, in the case of Luna Mabel, there is on paragraph 1 of it. It says the question is whether there must be a departure at all from the times prescribed in Rule 6.5 Rule 6 brackets 5b. Usually this involves a departure from time of 7, now 10 days, which must elapse from the date of service from the papers until the stated day for hearing. Once that is so, the requirements may be, this requirement may be ignored. The application may be set down for hearing on the first available motion day, but regarded must still be heard to the necessity of filing papers with registrar by preceding Thursday, so that it can come on to the following week motion roll, which will be prepared by the motion court judge on duty for that week. Now, according to Luna Mabel case judgment, the court said when we deal with agency Rule 6, it means that the time frames can be ignored. We have to set it for the next motion court date. And then I have to state it to this court to say, in actual sense, the motion court has passed last week, we came this week, and we never delayed to serve the respondent. The respondent was served on time.
No, it's not a question of service. It's a question of, as you have read there, ordinarily, that is what would happen. Because you get 7 days and then you get to the next court date, the roll, you get on the roll. But you have even collapsed that time period because Rule 6.5 says you are allowed to cut the time frames that are normally on the opposed roll. But you have even gone further and truncated those time periods. So it is important that you explain to the court why you went further and truncated those time periods, that time period.
My lady, as I gave an explanation to say on the Luna Mabel case, yes, the court says we can depart from the rules. Indeed. Then we have departed from the rules, and
but
we
you don't just depart.
Yes, we don't just depart.
You must have a reason why you
and those reasons, my lady, as I've already uttered them, and I'm coming in the aspect of the law to say this is a case that gives us a guidance to say we can depart from them.
Yes.
Then having departed from them, I then come to say, my lady, all these days that we're given here, having to look at the next court agent court date, this was more reasonable to say the respondent can still consult and respond because practice knows. Now, why did we move from the rules? We moved from the rules simply because we are catering the agent aspect of this matter. If we were to abide by the rules, then agency has been defeated because the next agent court date has passed. But then Luna Mabel case advised us to say you need to move in order for you to be able to be in court on the next agent court date. And if we could have brought it on extreme agent basis, we would have done so even on Friday, even any other time, but we did not. We came rather on Tuesday, which is today. So my lady, it is now clear to say, we are using these truncated times because we were measuring our time in line with the motion court date as advised by Luna Mabel case. And this Luna Mabel case states that we can depart from the rules, meaning the timelines as set by other rules. Then focus now on the timelines that we are setting for this. If ever they are filing late, they can even do a condonation for that. We understand it's an agent court. We're not going to hold them we're not going to hold them to the rules to say you should have filed this and that. As much as even now they never filed their answering affidavit, but we're here arguing them on only heads of arguments. Now, my lady, the issue of saying why is the 18 not on the papers? My lady, the 18th of March to say is the next court case of Thabo Bester is a public affair. The court can take a judicial notice of that. It's on TV, it's on radio, it's on newspapers, it's on all social media platforms. Now, the court knows that there is ongoing trial in Bloemfontein. And the fact that we never mention the details of the ongoing trial in Bloemfontein, we mention it to say because of the preparation of a case in Bloemfontein, we want the applicant to move this side for proper consultation and all this. Now, the court needs to understand to say there is that trial. It's not a manufactured or created imaginary case. It is there. It is happening, my lady. And the court must take a judicial notice of that. Now, if the court says this is not urgent because of the truncated times, the truncated times are not an issue in this regard. Rather, what is an issue in this regard is to say, are the rights of Mr. Thabo Bester being ignored by the respondent, or are they violated? So on and so forth. That's where the argument must come from. Now, the issue of agency to just say truncated times and all this, we have the guidance by the court to say we can depart. We have departed from that. We are sitting now on saying we have brought our own timelines. Why did we bring these timelines? Because we wanted this matter to be heard in an urgent court. And also, my lady, the respondent knows better when is the next court date of Mr. Thabo Bester. Actually, the respondent is present in court at all material times because the applicant, Mr. Thabo Bester, is arrested. He's in custody. So he's brought by them in court. We cannot tell them of the date that they know. When we say the 18th, they know that it's the 18th. They were in court on that day. It's there, it's evident. Mr. Bester cannot come to court without members of correctional supervision, whatever they are. Correctional services. They are there in court at all material times. So the 18th is known to them. Even when they were moving him to Ebongweni, they did that knowing full well that there is a trial. There is, my lady, to start with, they knew that on the 5th there is a court case arguing that we can't consult. Then after that, they still move him, ignoring all these issues. Now, it shows that these people were not interested in anything except to abuse their power. So we came on urgent basis because that needs to be corrected, my lady. And my lady, my colleague is reminding me something here. I think this will be my last part, if there is not any question. My lady, let us agree that the rules of the court are not an end in themselves. As pointed, but the court in a federated, that this, it has been federated in this by Buotha J. My lady, the rules of the court are not created for the court, but they are created by the court. It is the court that has to determine these rules to say this matter, do we see it as one that ought to be heard on urgent basis or not? The court does not exist because of the rules, but the rules exist because of the court. It was the court that came and made the rules. It is not the rules that made the court. So it is this court that must determine that, yes, according to what we're hearing, it is important that we hear this matter, despite the rules not being followed. As much as we are hearing this matter without all papers not being filed. It is a rule that they must file other papers, but they have not filed, yet we are listening to them. It should also be a rule to say, as much as this matter was followed without procedural times, let it be so. Why? Because we see it as urgent. As the court pleases, my lady. If there is no further question.
What would be the, we say that I must take judicial notice of the fact that the 18th of March 2026 is the trial date in Bloemfontein.
Yes, it's the last day of case management for...
What are the requirements that I must consider in order for me to take judicial notice.
What are the requirements? The public knowledge, my lady. My lady, this matter is a public knowledge. I think, my lady, the moment you were told that you'll be doing a case of Thabo Bester, there is something that came to your mind to know who Thabo Bester is. As the media speaks about him, as this case is a publicly known case. It is not something, it's not like if they say you are going to be doing a case of some Andrew Mataban, we'll have to go check who's that. When they say Thabo Bester, already you have an idea who that is. Now, when the court has to take a judicial notice, public knowledge, the known facts of this matter has to be taken into judicial notice.
Why I ask you what are the requirements is because even though I knew about this matter of Thabo Bester, the trial in Bloemfontein, I did not know that there was case management on the 18th of March 2026. So if you want me to take judicial notice of that, what would be the requirements that I should consider?
The requirements, my lady, you want me to discuss in detail what must inform the court to take a judicial notice. I do not understand the question, my lady. Maybe I need clarity. My lady, let me have a quick consultation with my colleague. My lady, necessarily when we speak of a judicial notice, is that it's a court acceptance for purposes of convenience without requiring parties proof of a well-known and indisputable fact. Meaning that it should not be brought, it's not something that I should be coming here to prove, to say, yes, there is a trial, there is no trial. The court must take judicial notice of that. It is there. It's a well-known factor. The public knowledge of it is there to say there is a case management that is happening in Bloemfontein. That case management then has got a lapse day to say on the 18th is the last day. And the respondent, who is the party to this, is fully aware of that. Now, when the court says, I did not know, it's a question of saying, how far can the court take a judicial notice when this is mentioned? Because on our papers, we don't mention dates as such. We do mention an issue of saying there is a trial preparation. This trial is it's ongoing, and it needs to be prepared for. And when we are not prepared for this trial, my lady, it becomes dire on the applicant.
And then your requirement to consult with client, is it an ongoing consultation, or do you have certain periods whenever you have to consult? Because it is not clear from the papers how is your plan for the consultation?
My lady, our consultation happened this way. This case is quite broad and it has got too many witnesses. There are too many pictures, videos, which they are on a laptop, some of them, they are there on a memory stick. Now, how our consultation is happening is that we have been on the first phases of consultation, whereby we are only dealing with affidavits, which are on paper form, that we are able to enter with them, that we printed. We did an application for the 5th of February 2026, whereby we were requesting that we be able to enter with gadgets in order for us to sit with the applicant and not see each other through that thick glass, and be able to discuss this video, what's happening here, who is this, who is that, so that we can fully prepare. Now, consultation has been happening according to the possibility of where we are. Meaning that we could only consult with paper-based, whereby if he does not hear on a phone, we put a paper on a window, he reads what is there, and then somewhere where a phone cannot be heard or where phone cannot be used, he will write down the notes and put it on the window. We write on the other side. That's how difficult is it to consult. And also it's so impossible also to consult on some issues because we rely on a phone. And this issue is about this very same first respondent because they say he escaped. Now, whenever we consult on a phone, we know that these phones have got records on the other end. It's difficult to prepare. So, my lady, the consultation has been happening at a very gradual pace, but necessarily not satisfactorily. It's not that effective as we want it.
So it happens as and when it is necessary to.
Oh, the time frame. Usually our consultations happen on Thursday or Friday. We book at least a space of 2 hours to 3 hours, depending on how the phones also are behaving. Because sometimes those phones are silent. The glass is so thick, you can't hear anything. You just have to read lips, so you must write notes on the other side. And also, my lady, must explain, must also state this. We are not only doing Thabo Bester case, we do this in between other cases. We do this in between other cases. And apart from this, my lady, as we stated in the application, there are many other applications incidental to this case that we are dealing with. We do have deportation application. We do have unfreezing of bank accounts application. We do have access to information application. All these applications are things we consult on. Yet knowing that we have all this going on, they still take him to Ebongweni. And they come to defend that he must not come back.
But now all this, what you are saying, is not in your founding papers.
It's not in?
In your founding papers.
It's there, my lady.
You are just saying.
No, my lady, it's there in our funding papers. We do say there are other applications that we are working on. You know, my lady, specifying some of these things to the respondent, he's the one who commissioned these papers. They read these papers. They know these papers.
And what about me?
My lady, you will also know that there are other applications as you read. Other applications. You will see that there are other applications going on. The details of it will be to bother you.
Is that all what you want to say?
My lady, let me consult with my instructing attorney briefly. I think there might be something that I might add on that. My lady, the last point that I want to say that my colleagues are also saying I must not forget. The truncated times, my lady, also they're informed by unexpected actions of this matter. Firstly, we're not informed. We have never been informed to this day. We only heard, as per our papers, that the applicant was moved to Ebongweni through his 1-minute phone call to the attorney. That please make an application. I have no time. I'm not allowed to make a phone call here. That's what he said. And then that's how we managed to, that's how we were able to move. So we did that because we are also worried about everything that has to do with him. His well-being is also a question here. His safety is also a question. If you are not able to talk to our client, how sure are we that he is safe? And my lady, just in passing, this has to raise an issue. How can they release him without even alerting us with a mandate claim that he escaped? What if they bring another Kahoot story that he escaped again? Because this is a question of saying if they can release this man without us knowing, what if they say he escaped again? Because they have that potential to do so. Finding out on saying Thabo Bester is not at Kosi Mamburu, how did it happen? As per our papers we state, one of the family members was booking to do a visit on Saturday. It was on Monday. And was told, actually it was on Tuesday, was told that no, he's no longer here, he's Ebongweni, Supermax. Then that's when they phoned the attorney to say, we hear that Thabo Bester is no longer here, he's at Ebongweni. Now, my lady, this situation on its own creates a lot that leaves undesirable results. A lot that leaves undesirable results. Therefore, it is on these factors that we are saying this matter must be heard on urgent basis. For all reasons that we have stated that are constitutional, even that are factual, related to the merits of this matter. And my lady, we read the heads of our senior counsel, very beautiful lecture. We appreciate this. I will use them in nearer future, but they are irrelevant for this course, as the court pleases.
Please record. My learned colleague has testified for a better half of what his argument to you was, because what he's arguing isn't in his papers, but you know that because you've read the papers. But maybe we should just take a step back and we should start at the beginning. Access to court for both the applicant and the respondents is mainly provided for by the rules of court, as the one court said in Makudam, which we've alerted you to in the heads of argument. Rule 612 provides for an exception in certain circumstances where there are urgency, where there is urgency. But there are requirements. You can't just run to court as you please. And the first of those are that you must set out explicitly the circumstances that you say render the matter urgent, and you must explicitly deal with the reasons why you say, the applicant, that you would not be afforded substantial redress at the hearing in due course. Now, what the applicant has done in this matter, it has afforded the respondents 1 day to file a notice of intention to oppose and 1 day to file an answering affidavit. Let's just contrast that to what the rule maker considers to be reasonable in the ordinary situation. 10 days for a respondent to consider an application, take advice, and decide whether he or she or it needs to oppose it. And then a further 15 court days to file answering affidavits. That's the ordinary time periods that Rule 6 caters for, that the lawmakers deems to be reasonable. The applicant here has afforded 1 day to give opposition and 1 day to file affidavits. Now, my lady, that is not only severely truncated, that is not, extreme is not even the word. It's ridiculous. And what then, if we look at the papers, what informs this deviation? Because Luna Meubels, and we've also referred you to the Caledon matter and the Rebuttal pers, they all say the same thing. The first question to be posed is, must there be a departure from the normal rules? The second question is actually the more important one. If so, what must that departure be, that deviation? That deviation, the case law says, must be commensurate with the degree of urgency that the applicant makes in his papers. Nowhere in the applicant's papers, with respect, my lady, has any case been made for a deviation so extreme as the applicant has done in this matter. It effectively meant that the respondents' access to court, their access to court, has been thrown under the bus. It's been infringed. If the applicant cannot and does not on his papers make a proper case for the deviation he seeks, then any deviation will be arbitrary. It infringes on the other party, the other party's rights. But there's another issue, and this is what Kalidon said. An applicant's not entitled to inconvenience the court, the administration of justice, and respondents more than is necessary. It's not entitled to do that. It's not his right to do that. So he must set out explicitly to this court, how do we arrive at a day and a day being just? And there's no case. There is no case for that. In order to try to justify it, our learned colleagues have gone outside the papers that they know they cannot do. In the papers, what the applicants in fact relied on, as you know well, is the 5th of February application, which has come and gone, and it's been judgment reserved, so that cannot constitute a ground of urgency that justifies the deviation. The second is that the applicant is currently an accused person in a criminal matter. They don't say in the papers, they don't deal with what preparation they've done, they don't deal with, they use terms that are vague, and I respectfully submit, intentionally so, to say a trial that's ongoing and so forth, but at a later stage in the argument you heard that it's actually a pre-trial date. It's not a trial. So
they also say the court must take judicial notice of that day,
Malari,
even though it's not in their papers.
whether I can give you the requirements to take a judicial notice for what it's worth, but if you take judicial notice that the 18th of March 2026 is a pre-trial, it doesn't assist the applicant at all, because it's not the trial that commences. That's the impression they created in the papers, but that's not the trial that commences. It's a mandatory pre-trial. So I don't understand to what extent that, in fact, it doesn't help them, because if they've had challenges with being ready for trial, then that is the proper forum where they'll be able to raise it.
Won't they need to consult with their client to prepare for the pre-trial?
But my lady, they don't say they can't. They just say it's going to be difficult. But that's not the point. The point is, does that fact, which is not in the papers, justify the deviation that the applicant has sought here? That's the question. The fact that's not in the papers, does that justify the time frames, the deviation? Does that constitute urgency to such an extent that the severe deviation from a time periods that are prescribed ordinarily, but makes it commensurate with a degree of urgency? And the answer is a resounding no, my lady. It is not. And it is not fair case that they haven't consulted. They have. They just don't tell you where they are with regards to preparation. There's nothing in the papers with regards to that. What you have, what one often sees in these kinds of applications, is general allegations, no specifics, no primary facts that's entered into evidence, specifically with regards to the urgency issue. And that is not in compliance with Rule 612, because that's exactly what Rule 612 wants to avoid. That's why it says you must expressly deal with these matters. And they haven't. They haven't shown that the applicant will not be afforded some substantial redress. And I just need to clarify something which it appears to me the applicant, I'm not sure whether they... The question is not whether there would be substantial redress in the normal course of events. That is a question that's posed. But when you look at whether the deviation is justified, then the question is, why didn't you give a respondent 10 days? Why not? Why did you give him 1 day? Why didn't you give him 5 days notice to oppose? Why did you only give him 1 day? And there's no answer. My lady will find none in the papers. My lady would find none in the submissions that have been made on behalf of the applicant, because it's not justifiable. What they've done cannot be justified.
If I understood the argument correctly, Mr. Maila is saying that holistically, the case holistically, if you look at it, because the constitutional rights of their client is being trampled on, so you look at the case holistically, you'll see that it requires to be attended urgently.
My lady, if we've referred you to the case law that says that an allegation that conduct is unconstitutional doesn't make it inherently urgent. We've cited those cases in our heads, firstly. Secondly, looking holistically at this case, my lady, still, on what they've put before you, doesn't make the time, the deviation from a normal times, commensurate with the degree of urgency they claim. The respondents are entitled, my lady, to be afforded a reasonably justifiable period when somebody comes to court on an urgent basis to put their case before court. But they haven't been given that because the applicant has not complied with requirements of Rule 612. It hasn't made a case for that, what he seeks from the court. I'm just referring you to paragraph 14 of our heads where we've dealt with that issue, that an alleged infringement of a constitutional right does not render a matter urgent. You must still comply with your requirements for urgency. So, my lady, in a nutshell, on behalf of the respondents, as far as the urgency goes, those are the submissions. You'll remember that we've addressed you in the head specifically with regards to a cost order if you strike it. That's in your discretion, and obviously we've alerted you to the BioWatch principle. And obviously the question in this matter would be whether it finds application if you find that the applicant was not reasonable in his conduct in approaching the court. And the alternative relief, as I stated when I stood up the first time, if the court is not minded to strike it, then the court must afford the respondents a reasonable opportunity to oppose this application. But our primary submission is that the applicant has willfully failed with respect to justify the deviation that it's seeking here. The extremely truncated time periods, not justifiable on what's on the papers. May I just take an instruction quickly, my lady?
Yes.
May it please you, my lady.
Thank you.
As the court pleases. My learned colleague says we said in our funding affidavit that the matter is not inherently urgent. He says it in paragraph 16 of the funding affidavit of his heads of arguments to say it's on 011-9. And then he's quoting us on our funding affidavit on 001-11. He's quoting 4.1 paragraph. And he's misquoting us. Here it is written, I respectfully submit to the Honorable Court that this matter is inherently urgent.
No, I don't think you've written that properly.
No, my lady.
Paragraph 16.
Yes, of the heads of the respondents' heads of arguments.
Yes, it says contrary to what Ms. Morel says in paragraph 4.1 of the founding affidavit, this application is not inherently urgent. This is what they say. They don't say that.
But when he's speaking about it, he says, he says, on our papers we said.
not, I didn't get that.
No, it says on our papers we said that, but in our papers we said this matter is inherently urgent.
Yes.
And also, my lady, on the heads of arguments here of the...
I take exception. I've been accused of misquoting something that I haven't done.
I don't remember it also.
If it pleases the court.
That's why I said maybe I missed it.
Yes, but maybe my learned colleague must just read that sentence again and then apologize.
My lady, I read the sentence, I even underlined it with red. I'm speaking about what my colleague said in court. If I never heard what he said properly, I apologize for that. Let me proceed. My lady, there is here on their heads of arguments on paragraph, I think it's 14, they just write one line here, they said, an alleged infringement of a constitutional right does not render a matter urgent. An alleged infringement of constitutional right does not render a matter urgent. Now, the question is that what will render a matter urgent if the infringement, an alleged infringement, is not? Because it is this court that has to determine whether indeed the matter is urgent. When they said an alleged is not, then it's a question of saying it means that we should not come to court when there is an alleged infringement, which we should. And also, my learned colleague.
No, but does that not mean that an alleged infringement of a constitutional right does not render a matter urgent? In order to render it urgent, there need to be an explanation. Well, like you are saying, you explaining why these constitutional rights that have been trampled are urgent. It does not necessarily mean because there is this an alleged infringement, then you cannot come. You have to come, but you explain why you need to do it.
Yes, my lady, we did explain that.
Yes.
They should have at least filed their papers to respond to that, to say what do they mean by some of the statements. We are arguing on a very peripheral angle because we don't have their supporting papers to the merits of this matter. But I will proceed on that. Also, my learned colleagues state that you can run to court as you please. My lady, we did not come as we please. We filed all the papers necessary. And we did raise a rule that gives us that room to have the rules having to be bended or departed from. And we did even reason from the case laws to say, why are we departing from the rules? And also, my lady, another issue is that my learned colleague says it's a pre-trial date, it's not a trial. We cannot have a trial without this pre-trial. And the reason we have a pre-trial is to ascertain whether all issues have been covered, can we go for a trial? Because once trial starts, there is no chance to consult further. It's a trial. So you cannot separate the pre-trial from a trial. Unless if they are explained somehow. But pre-trial requires a very serious preparation, because if we go for a pre-trial without having fully consulted, the matter is set down, then we're going to have a crisis. Now, when he says this, he simply says a right to consult with a legal practitioner is not that important. And it is important at any phase of a trial. Pre-trial, in a trial, it is important to consult. When he says the time, the time truncated is not justified. My lady, I stood here for almost 30 minutes justifying why we had these truncated times. And to a certain extent, the court has to look necessarily into saying all these reasons that we've given why we had to move this matter faster. Having engaged the court to say all things that are relating to this matter, to Mr. Thabo Bester, they need to be taken into judicial notice, including the date of the next trial. My colleague should have been informed by his client to say there is a trial coming, if he's not aware. And also in my heads of in the applicant's heads of arguments on 009-9, paragraph 26, there is a case there that is being mentioned. The case of Mogalakwena Local Municipality versus Provincial Executive Council of Limpopo.
What page is this on?
is page 009-9.
Paragraph.
Paragraph 26, my lady. It reads as follows. In the case of Mogala Kwena Local Municipality, the Provincial Executive Council of Limpopo and others. This is a view expressed by Judge Tuchen in paragraph 64, which reads, it seems to me that the agency is an issue when the primary investigation should be to determine whether the applicant will be afforded substantial redress at the hearing in due course. If the applicant cannot establish prejudice in this sense, the application cannot be urgent. On such prejudice, once such prejudice is established, other factors come into consideration. Now, my lady, we have already explained a prejudice that Mr. Thabo Bester will suffer if this matter is not heard urgently. One of those, we talk about the trial preparation, which is undergoing. To say, we were even on court on the 5th of February to address the issues of challenges with consultation. When we are busy addressing such issues, the respondent chooses to ignore everything. Rather, he moves the applicant further. We already are raising issues to say we want to consult. We can't consult. We are in court on the 5th. Before we get to the court, he already moved the applicant. Now, it shows that the rights of the applicant have never been taken into cognizance. When my colleague talks about the 5th, he says it has already happened. He does not understand the implication of the 5th of February to say it was in relation to the right to consult and to have adequate facilities to prepare for a trial. Now,
But-
such have never
But
been.
that was then before the 5th. Does it still have application even now?
Before,
Before the 5th? It was
my
important.
lady, now is no longer an application. An application, let me explain this, my lady. An application on the 5th was to say he is at Kosi Mampuru. We do come to consult, but it's not an effective consultation because of this and that reasons, as I explained. Now, that was a difficult situation to consult. Now it's no longer just a difficult situation to consult. It's an impossible situation to consult. It has become a triple case.
So you are using the 5th of the case of the 5th of February just as an example.
I'm using it as an example of saying, my lady,
Yes, the difficulties that you
yeah, it's a difficulty to consult situation we are bringing to the respondent, that the court must order them to give us that chance to consult. Then, as the matter stands like that, before we even get to court to argue that, then they move the person to Ebongweni. They no longer make it difficult, they make it impossible. For example, my lady, it's the same as saying you come, you say, my hand was beaten and I cut it. That's the same situation. I worsen your situation.
But Mr. Maila, I still do not understand the issue of the 5th of the application of the 5th of February to have been a stumbling block in this matter, because in your papers you're saying he was going to represent himself in that.
Yes, my lady, I want to explain this. What were we going to... Now, him having to represent himself doesn't take away effect that there is a legal team that assists him. Because number one, he has no laptop to file on case line. Number two, he cannot type the papers. All these papers are typed. Who's typing them? Who's also citing the laws for him? A fact that I'm not available to argue on the 5th doesn't take away a fact that I'm part of the case.
You know, the difficulty becomes then again that those things are not in your papers. Like
Now,
because now you are saying them from the back.
No, my lady, I'm explaining the 5th. I want to explain the 5th. I wanted to pass the issue of saying he represented himself to say it is outside and it's beside an argument of this or of this whole issue. The issue of the 5th, I'm saying, my lady, the contents of the application on the 5th was to argue the difficulties to consult for the trial that will be set down on the 18th of March. To say, kindly give us at least a period of 7 days or maybe a period of this to be able to consult with our client. Coming with laptops, memory sticks, so that we can show him some of the videos given to us when disclosure was done. and we'll be able to engage that. Now, having those challenges of consulting, my lady, having approached a court on it on the 5th, now the very same respondent sees not such as an issue. He then moves him from most difficult situation. He put him in an impossible situation. How are we then going to consult when he's at Ebongweni, Supermax? My lady, just to break it down, if I have to go and consult with Mr. Thabo Bester together with the attorney at Ebongweni, it will cost something like 120,000. Simple as that. Why? Because to travel there, we have to charge per kilo to drive there. Every kilo has to be charged at 14 rand. When we arrive there, we have to still charge per hour of consultation. We have to sleep, we have to eat. And then everyone who's on the road is charging per hour for that road. So my lady, we are saying it has been difficult to consult at Khosi Mampuru where we drive 10 Ks or 5 Ks to there from my office here, from my chamber here. But then also when he's moved to Ebongweni, it is more than difficult, it is impossible. And then it is also in our papers that all these issues, we have argued them. From the case that I've already read of Mogalakwena, local municipality, Judge Tujan raises a very important issue that we need to establish prejudice. Once prejudice is established, other factors can be considered. A prejudice of Mr. Thabo Bester for moving to Ebongweni greatly is his preparation for the main trial. That's what created the agency. That prejudice, it did. The constitutionality of the aspect of saying his rights have been violated, and procedurally and unfairly. That is what the court needs to consider in order for the court to hear this matter out. We ventilate everything and the court grants an order. So the agency of saying we did not follow 10 days and whatnot. My lady, we have not 10 days. We don't have that luxury of time. We are under pressure as matter stands. We need to consult with our client. Our client need to move back to Pretoria, and we continue with this matter. Or we continue with preparation on the trial that is ongoing in Bloemfontein.
That, you know, when you say you are under pressure, that is why that is why the issue of that court date or pre-trial date, I thought it would have been very important for you to have put in your papers to show the pressure, because without that time, that court date, it's not easy for a person reading the papers to see any pressure there. But then you are saying the court must take judicial notice of it.
Yes, my lady. The court is allowed to take judicial notice of matters that are apparent. My lady, on page 001-22, paragraph 11, a detainee in the middle of a trial is the heading.
What paragraph is it?
001-22. Paragraph 11. That's a page. Paragraph 11 is 11.1 and 11.2. It is, we state that when the applicant was previously sentenced, he is also currently awaiting trial in Bloemfontein High Court. As such, it is even more imperative that he be allowed to have access to his legal representative to allow for him to participate in his own defense. 11.2, it says, it is apparent that if DCS is allowed to separate the applicant from his legal team that is located in Gauteng, the criminal trial of which he is the seventh accused will be adversely affected and will inevitably be delayed. This will curtail the rights of the rest of the defendant to a speedy trial. Now, we did state, my lady, to say we have a trial, and that trial is being affected by the decision of the first respondent. And my lady, we did state also in our papers, in our funding affidavit, to say we send an email to the DSC to say kindly don't continue with the transfer, even though it's there, return him as soon as possible. Why? Because we are in the middle of this. The email is attached as one of the annexures. But then all this were never heard or taken into cognizance. Why? Because the first respondent can bully anyone and violate anyone's rights and come to court and say an alleged infringement of rights does not constitute agents. Meaning when your rights are being violated, you must sit back and relax and enjoy the abuse. And smile and say, yes, Department of Correctional Services is abusing me, I must enjoy. Normally, the applicant has all the right to approach this court on urgent basis. In actual sense, by giving them 1 day truncated time, it was a grace. We should have come on extreme agents. As the court pleases me. That's my submission.
Thank you. Thank you for your arguments and the hits of arguments that you've provided. I'll have to take time to consider your application and then come back to give judgment. Court agents.
Court pleases.
Nominated on the letter of Thabo Bester, case number 02-1077 of 2026.
Maybe I have to apologize for taking this long to coming back, but I had to read through the cases that were on the respondents' heads of arguments, because I had not gone through them before. That was kept me to take longer. But anyway, I have reached a decision, and I've written just a small, a brief judgment that I'm just going to read out. The applicant, Thabo Bester, approached this court on an urgent basis, basically seeking this court to declare his transfer to Ebongweni Supermax Correctional Services Center to be unlawful, invalid, and unconstitutional, and that he be returned back to the CMAX section of the Khosi Mampuri II Correctional Facility, where he had been detained for the past 3 years. The application is opposed, but the Asari affidavit was not filed. The respondents have, however, filed heads of argument challenging the agency. In terms of the notice of motion, the respondent was afforded 1 day to file the notice of intention to oppose and 1 day to file an answering affidavit. The time frames have been severely truncated, thus the application was brought on an extremely urgent basis. The question is whether this application warrants these truncated periods, and if it does not, whether the application remains urgent. Urgency involves mainly the abridgment of times prescribed by the rules, and secondarily the departure from established filing sitting times of the court. The ordinary time frames allowed for application proceedings are set out in Rule 6.5 of the Uniform Rules of Court. In addition thereto, the rules provide for a deviation from those time frames where there is urgency. Urgency is regulated in terms of Rule 6, sub-Rule 12 of the Uniform Rules of Court. The rule sets out a procedure to be followed when a deviation is required. Firstly, an application must be made to the court requesting it to dispense with the forms and service provided for in the rules and allow the matter to be heard as one of urgency. The application must be supported by an affidavit setting forth explicitly the circumstances which is averred render the matter urgent and the reasons why the applicant claims that he could not be afforded substantial redress in due course. Quoting from the case of Luna Meubles that was cited by both the applicant and the respondents, when setting down the matter on the urgent role, practitioners are cautioned to carefully analyze the facts of each case to determine whether a greater or lesser degree of relaxation of the rules and the ordinary practice of the court is required. The degree of relaxation should not be greater than the exigency of these demands. It must be commensurate therewith, and the applicant must make out a case in the founding affidavit to justify the particular extent of the departure from the norm. In the instant case, the explanation provided for the deviation as per the founding affidavit is that the applicant is currently an accused person in an active and ongoing criminal case pending before the Free State High Court, and as a result, the transfer severely restricts and prevents consultation with his legal team and undermines the need for preparation for trial. It should be remembered that the applicant is required to make out a case in the founding affidavit to justify the particular extent of the departure from the norm. This does not appear from these reasons, the first reason that was given. However, in oral argument in court, counsel for the applicant mentioned that the matter is set down for a final pre-trial on 18th March 2026. This is a fact that is not mentioned in the founding affidavit, and it was argued that the court should take judicial notice thereof. This fact, however, does not take the applicant's matter any further because it does not explain why it was not necessary to afford the respondent only 1 day instead of the number of days ordinarily afforded respondents in urgent matters. The argument was made orally again that the applicant is under pressure because he requires to prepare for the pre-trial with his legal team, which is far from him. However, this pressure is not apparent from the founding affidavit, mainly in my view because the court was not made aware that the pre-trial is to be held on the 18th of March 2026. The second reason provided is that the transfer prejudices the applicant and interferes with his preparation for the civil case before the Free State High Court, which was held on the 5th of February 2026. The civil case, in my view, does not have any relevance in this matter as it has already been heard. In any event, it would not have restricted the applicant's consultation with his legal team because in the founding affidavit, it is specifically stated that the applicant was self-representing in this matter. The argument in court by the applicant's counsel that this matter serves as an example to indicate the extent at which consultation with the legal representatives was restricted because the applicant was transferred 750 kilometers away from his legal team makes no sense to me. This in any way was argument from the bar, not contained in the founding affidavit. There is therefore no cogent reason mentioned in the founding affidavit why this matter was set down on such stringent time frames without giving the respondent adequate time to file their answering affidavits. I am thus not persuaded that this matter is so urgent that anything more drastic than enrollment on the motion roll in the ordinary course and on short notice is required. The matter is to be struck off the roll because it was not properly enrolled, and the applicant is at liberty, if he so wishes, to enroll it properly for the next urgent court roll. In the exercise of my discretion, I am of the view that the bio-watch principle is applicable in this matter. Constitutional rights are at issue and no order of court should be made. As a result, I make the following order. The matter is struck off the roll. Still no. There is no appearance and the matter is struck from the roll. And the court adjourns.